Thank you, Chair, members of the committee, for the opportunity. I speak in support of this good bill. I ask you to vote for it. My name is Brian Vandiver. I'm an attorney. I've been practicing for 20 years in this area. And the reason I'm here today, I am a father of 3 children. And I'm advocating not for myself, but for parents, moms and dads in the future that come through our system, because I've seen it. I've experienced it. And it's a system where if the preponderance of the evidence, a feather of evidence falls one way or the other, that's the difference between being a custodial parent or being a visitor relegated to every other weekend. And a lot of them have said presumption of clear and convincing evidence is too high. Well, it's not too high, it's appropriately high. These cases are important. They're deciding fundamental rights between children and their parents. These are not car wreck cases. These are cases that will impact people's lives forever. And so we should start where the parents share equal custody. If both parents are fit parents, our policy as a state should require clear and convincing evidence why joint custody and equal time with each parent is not proper. Period. Full stop. This is consistent with protecting the rights of the children and the parents, and it also will reduce litigation. Contrary to what you've heard, the studies from Kentucky and Arizona clearly show that litigation is reduced when you have a presumption of joint custody. Now, I'll give you some other examples because I am an attorney and I know the law, and we all share the same degree. I don't practice family law, but I practice law. I could take divorce cases tomorrow if I wanted to. I choose not to. But I understand the clear and convincing burden of proof, and it's elsewhere in our law where important interests are in stake. For example, defamation against a public figure, like elected representatives. If you want to prove defamation against the newspaper or someone in the public, you have to prove that by clear and convincing evidence. Why? Because that protects the free speech rights of the public. If we want to, in Arkansas, award punitive damages against a corporation, you have to prove that by clear and convincing evidence. Why? We protect corporations and other tort defendants from punitive damages. If parties to a contract or a will want to change the terms of the written agreement, you have to do that with clear and convincing evidence that that was not the intent of the parties. Why? Because we protect the parties in that agreement. Are these types of cases less important than those? I think not. Child custody cases are some of the most important cases in our system. Why should we let a feather of evidence tip the scales one way or the other that impacts the lives of children and parents forever? We shouldn't. That's why this burden is so important. It's why it's so crucial, and it's why you hear a lot of family law attorneys argue against it, because they know it will reduce litigation. And that's the point of it. To reduce litigation, to lessen the conflict, to take families who are throwing these petty grievances against each other out of the court system, encourage them to settle, because if they know going into the litigation, if any attorney knows the law has changed, they will tell that parent, you shouldn't fight about this because you don't have really a chance with these petty grievances. You need real evidence to change custody. Finally, this bill is about equality. It's about parental equality. It's about gender equality. If you believe in equality, how can you vote against this bill? Because we know the stats show that 80% of sole custody... Your time is concluded. I appreciate you very much. I ask you to support this bill.
Any questions for this witness?